Thank you for being here today with us, Professor Yoshino. It's a pleasure to have you as a guest on our podcast today.
Oh, it's my great pleasure to be with you. Thank you.
How has Brown versus Board of Education impacted your life and your career?
Yeah, so I have spent 25 years in the legal academy as a scholar of the Constitution and particularly of anti-discrimination law. So it's really hard to imagine, anything in the ambit of what I do that doesn't have Brown as a kind of superintending presence over all of it. I don't know if they still say this day. I mean, I think we might get to this. But when I was in law school, we were all taught that anyone who says that Brown versus Board of Education was wrongly decided is themselves wrong, right? So it was one of the kind of big stars of our legal firmament, and I've learned and benefited so much, not just as a scholar of racial civil rights, but of gender and particularly of sexual orientation, which is my main field of research, from thinking about the promise of Brown and how this nation can still live up to the ideals that it's still, unfortunately, still living under rather than up to.
And so, your named professor, your chaired position is the Chief Justice Earl Warren, Professor of Constitutional Law at NYU School of Law. And so, can you talk about the significance of that named chair position in relation to Brown versus Board of Education?
Yes. So Chief Justice Earl Warren was the canonical Supreme Court justice who wrote the opinion in Brown v. Board for a unanimous court, and as a former governor, kind of strove mightily to create a unanimous opinion. I say governor because he was a eminent, politician, and so he knew how to kind of work the court in order to get
Mhm.
unanimity, so there wouldn't be any kind of fractures within the opinion, particularly from folks like Justice Jackson or Justice Reed, who are thinking about concurring or dissenting. So that's all you need to know as background to the story. But the story really has to do with the name of my chair, which, as you said, is Chief Justice Earl Warren Professorship of Constitutional Law. I came to NYU in 2008. I was tenured and chaired at another institution, Yale, and was very, very happy there. I came here because my husband and I were thinking about starting a family, and we both wanted to be in the same city to do that. And he works in New York. And so I was not able to convince him that New Haven, Connecticut was a city in which we should raise our children. I was not even able to convince him, Karla, that New Haven, Connecticut was a city. So I
Oh,
revere
interesting.
Yale, so no shade at all on
Mhm.
my prior institution at all. But I sort of bit the bullet and I applied to some schools in New York City and was fortunate to get some offers. And then the recruiting season began. Then the dean of NYU at the time, Richard Revaz, called me up and he said, "We have tried to find a chair that would be as significant to you as the chair you currently occupy, because we know that the chair you have at Yale is of deep sentimental significance for you because it was named after the judge for whom you clerked, Guido Calabresi, in the Second Circuit. So we tried to find a chair that would be as emotionally significant as that chair. We couldn't find one. And so we took the extraordinary step of creating a new chair. We raised $5 million and we endowed this chair called the Earl Warren Professorship of Constitutional Law. And this was with you in mind. It was really to honor, as we were just talking about, the work that you do at the intersection of constitutional law and civil rights law. What better title could you have than this? And we hope that you will come and be the inaugural holder of that chair. And I will say that every people-pleasing bone in my body just wanted to take the chair and
Uh-huh.
not sort of look behind it because, it had been offered with all the goodwill in the world. But I write a lot on how, assimilation cannot be the predicate for equality. This is my work uncovering. And I knew that it
Mhm.
would be a form of kind of self-disregard and shame if I didn't stick up for myself in that moment. So finally I said, "Ricky, I can't take that chair." And he was astonished, and I could tell a little bit annoyed. And he said, "Why on earth not? I hope that you understand how much work went into this." And I said, "Of course, I'm totally sensible to that. But as you may know, I'm of Japanese descent. And as you may know, as Attorney General of California, Earl Warren superintended the internment of over 100,000 individuals of Japanese ancestry without any criminal charges or due process. And I cannot be honored with the name of a person who has so dishonored my people. And Ricky immediately took that in and he said, please don't make any sudden movements, i.e. don't go to another school. I'll call you back in 3 days. So sure enough, 3 days later, the phone in my office rings. I pick it up and it's Ricky. And he says, I have a new chair for you. And I said, great, lay it on me. And he said, we want to offer you the Chief Justice, Earl Warren Professorship of Constitutional Law. And this time, Karla, I was the one who was astonished and a little bit annoyed, to be candid. And I said to him, Ricky, you've just taken the chair that I rejected 3 days ago, tacked on the words Chief Justice to the front of it, and flipped it back to me as if it were a new chair. So, what's going on? Like, how silly do you think I am? And he said, please hear me out. In the days since our last conversation, I've read a biography of Earl Warren. And as Chief Justice of the United States Supreme Court, who wrote opinions not just Brown versus Board of Education, but also opinions like Loving versus Virginia, which legalized interracial marriage throughout the land in 1967, he said that the thing that he most regretted, Earl Warren said the thing he most regretted about his career was the internment of the Japanese. And he said, given that your project is a project of civil rights and of taking people as far along the maturity curve of understanding how many different valid ways there are to be a human being, what better title could you have than the name of an individual who was able to travel so far on that journey over the course of a single lifetime, but to have the title that he held at the end rather than at the beginning of that journey. And I said, Ricky, that chair I can take. And so I come to you today on this wonderful podcast as a Chief Justice, Earl Warren, Professor of Constitutional Law.
Thanks. That's such a wonderful story. Can you talk to us about how Justice Warren got, the Supreme Court justices to interpret the 14th Amendment and how historically significant that was in Brown versus Board of Education?
Yeah, so the thing that was remarkable about Earl Warren, as I mentioned before, is that he came to the court as a politician. So prior to Brown versus Board, I think we often forget this. I mean, you certainly know this, but I think many people who are just listening in may or may not, which is that Brown versus Board was far from a preordained outcome. We've so naturalized it in our constitutional history that it's hard to imagine the opinion coming out, any other way. But the issue was really in doubt, and they had to set the case for re-argument because there were such fissures on the court. Between the first and the second, oral arguments, Chief Justice Vinson died, which led Justice Frankfurter to say that this is the closest he'd ever come to believing in God, because Vinson was seen as a much more tepid, to put it gently, advocate of the, equality principle that Brown ultimately embraced. And then Chief Justice Earl Warren stepped into that role, and then he really worked the court. I mean, he created an opinion that was so clear and plain spoken. So he said, I want this opinion to be short, readable by the lay public, and above all, non-accusatory. And so he was really able to message to the country what the promise of the 14th Amendment was and how it was critical to actually apply the Equal Protection Clause of the 14th Amendment to desegregate primary and secondary school, education. And so he then, after kind of drafting, the outlines of this opinion, had to persuade others on the court. So Justice Jackson was going to write a concurrence. And so he very cleverly went to go visit Jackson first, because he also knew that Justice Reed, who was a kind of son of the South, was going to dissent or was planning to dissent. So he got rid of Jackson first. He went to Jackson in his hospital room, and no one really knows what happened in that conversation, which was private, but he emerged with his signature right on the opinion. And then he went to Stanley Reed and said, Stan, you're all alone in this now. You have to decide what's best for the country. And so he really kind of isolated the naysayers, because he knew that any fracture or fissure within the opinion would be a massive toehold for individuals who wanted to see segregation continue in the United States. And so he was able to flip Stanley Reed and then publish this kind of ringing, opinion that, to this day, as we started the conversation talking about, is the most canonical, right, opinion on constitutional law. So, you might not know anything else about, constitutional law, but everybody knows what Brown versus Board of Education in 1954 was and what it did.
Talk about most people don't know the fact that Brown versus Board of Education, as you mentioned, there were two oral arguments. And so, can you talk about that? What the Brown lawyers did when they came back for that re-argument before the court, and why did they have to do a second oral argument?
Yeah, so in some ways, I feel bad for poor Thurgood Marshall and Spotswood Robinson from the NAACP who had to, re-argue the case, because in some ways it was just a pure stalling technique. They couldn't get the decision done because, again, there was such dissensus on the court. And what broke the logjam, right, as is commonly interpreted by historians, was not so much any particular argument, but simply the death of Chief Justice Vinson. Hence, Felix Frankfurter's, comment about how it just seemed like Deus ex machina kind of move by the universe, right, rather than any particular argument that won. But they had to have some sort of pretext, at least, for why they needed re-argument. And they said, essentially, all of this is going to turn on intent. And so what was the intent of the framers of the 14th Amendment? So the 14th Amendment was ratified in 1868. Brown versus Board of Education was decided in 1954. And so the question was, back during the Reconstruction period, did the framers of the 14th Amendment, which says no state shall deny to any person within its jurisdiction the equal protection of the laws, did that provision intend to desegregate public education? And, Marshall and Robinson did their incredible, as always, job of arguing, first of all, that there was, clear intent for desegregation to occur. Second of all, even if there wasn't, direct intent on the basis of the framers, in pitching the Equal Protection Clause at such a high level of generality, like they didn't say equal protection on the basis of race. They didn't say equal protection on the basis of race in public employment. They left it really, really abstract. And so they said that by adverting to that high level of generality, the framers of the 14th Amendment intended for the Equal Protection Clause to be available for reinterpretation by every successive generation. So the fact that the Equal Protection Clause now covers, sex discrimination, now covers discrimination on the basis of sexual orientation, it would have been shocking, I think, to the framers of the 14th Amendment. But Robinson and Marshall's argument was they chose a high enough level of generality that they contemplated that it would be the left to the intelligence of every successive generation to imbue the promise of equality with the meaning that it had during that generation. And so those were the two main intentionalist arguments. And then they also had some arguments. These are all requested by the court, right? So there were three questions. One was it the specific intent of the framers to desegregate schools? Another one was it the general intent in the way that I just described? And the third one was, let's say intent doesn't matter. Are there other, reasons why we should intervene here? And so they just kind of knocked it out of the park, all the way down the line. But then ultimately, when Brown was handed down in 1954, I think it was pretty clear. I don't think there was that much debate about the fact that this is just a stalling device. And I think it's clear from the opinion that the intent didn't really ultimately matter that much, because the way in which the court dealt with the issue was to say it's really hard to think about what the framers thought about public education, because public education in the way that we have it in 1954 simply didn't exist during Reconstruction. We didn't have a broad-based system of public school education. So if a thing doesn't exist, it's really hard to imagine how a legal principle would apply to that thing that doesn't really exist. And so that's how they did an end run around the intent question, showing that the intent question wasn't really what was detaining them, and really what they were doing was stalling for more time.
Right. So it's really important that our listeners understand this historical context of the 14th Amendment. So can you talk about the 14th Amendment and Brown in the context of the Reconstruction Amendments and how that impacted and arguably impacts today our interpretation of the 14th Amendment.
Yes, absolutely. So the Reconstruction Amendments were passed during the Reconstruction period, after the Civil War ended. And so these are three amendments, the 13th, 14th, and 15th Amendments. And the 14th Amendment, which is the subject of our conversation today, is the one that was enacted or ratified in 1868. So the 13th Amendment abolishes slavery, and the 15th Amendment establishes the right to vote regardless of race. But the 14th Amendment is more general and more soaring in its aspirations. And the first thing that it does is to say, anyone who is born within the United States is a citizen of the United States and in the state in which they reside. And so this undid one of the greatest injustices of this country's constitutional history, which was the Dred Scott decision, which said Black individuals simply were not citizens of the United States simply by dint of their race and had no rights which the white man needed to respect, right? So paraphrasing from the opinion there. And so the citizenship clause of the 14th Amendment is really often overlooked or elided in favor of the equal protection or due process or the privileges or immunities clause. But really, the 14th Amendment begins with that great promise of citizenship. And then the clause goes on to say, or the amendment goes on to contain the equal protection clause, which was at issue in Brown. And as mentioned earlier, this is the home of the equality principle within the Constitution. And it states that no state shall deny to any person within its jurisdiction the equal protection of the laws. So in essence, what the 14th Amendment was trying to do is to undo all of the kind of vestiges of slavery and to bring people, regardless of their race, onto an equal footing. And the critical thing about the Equal Protection Clause, and this becomes relevant not just for Brown, but for contemporary discussions that we're having today about the meaning of the 14th Amendment, is that it's very, very clear from the history of the 14th Amendment that the framers of the 14th Amendment wanted to embrace an anti-subordination view rather than an anti-classification view of equality. So what do I mean by that? The anti-classification view, let's start with that, is a so-called colorblindness theory. And it says you are not allowed to use race when you are government for any purpose whatsoever without raising the highest level of judicial skepticism known as strict scrutiny review. And the reason for that is that if we allow government to use race-based classifications, it teaches us all as citizens, because government is a teacher, to view each other on the basis of our racial characteristics. And we'll be much better off if we all kind of diminish the salience of race in our lives. And the way to do that is to engage in colorblindness. So forgive my ableist language there, but this is the metaphor that's used all the time. Even if you sort of look at that metaphor, I think that we can see how inapt it is. Because if I am medically colorblind, I literally cannot tell the difference between the color red and the color green. When I say that I'm politically or jurisprudentially colorblind, I'm not saying that I can't tell the difference between a Black person and an Asian person or a white person. I'm saying I can tell the difference between these individuals. But, I think that this classification is so pernicious that I'm just going to pretend that this distinction doesn't exist. And given that that project of repression is always going to be fraught and incomplete, we can expect that we're not going to get that many gains from a colorblindness approach. So what is the countervailing view? The countervailing view is the anti-subordination approach. And the anti-subordination view says it's not classifications in and of themselves that are problematic. With regard to race, it's the end to which those race-based classifications are put. So if I'm using a race-based classification in order to deny a historically subordinated group of their rights, like, the Strouder case where Black individuals are not allowed to serve on juries, or the Loving case that I mentioned where interracial marriage was prohibited, or just Jim Crow generally, then of course, that should raise all of our hackles and alarm bells, and we should strike it down as a matter of our equality jurisprudence. However, there are forms of race-based classifications that can be used in order to remedy a long history of discrimination. And in fact, is going to be the most effective way to get rid of that history of discrimination, because we have to talk about what we're talking about. So if we're talking about centuries of slavery and race discrimination, the most efficacious way to remedy that is to directly talk about race and to say, we're going to engage in affirmative action. We're going to engage in racially conscious remedies. So this battle between the anti-classification view and the anti-subordination view has been waging ever since the 14th Amendment was ratified, and is a core claim of all race-based civil rights struggles from the jump. And so one of the things that we see the court doing, particularly in the Students for Fair Admission versus Harvard case, which I hope we'll talk about later on this podcast, which was decided, that's kind of unimaginable, but a little over a year ago in 2023
Okay.
on June 9th, the Supreme Court embraced the anti-classification view. And if you are, a progressive scholar, or if you are an originalist scholar, that should really, really trouble you. Because it's not just that the anti-classification view pretends that this long history of race discrimination doesn't exist, or that the best way to get past it is to pretend that these race-based classifications are not salient in our society today as a matter of governmental action. Or, if you're an originalist, you should also be troubled by this because, and this gets to the nub of your question, the framers of the 14th Amendment were very, very clear that they were embracing the anti-subordination view rather than the anti-classification view. What's remarkable about this is that back in the time period, they didn't need to choose, right? Because both the anti-classification view and the anti-subordination view would lead to the invalidation of racially discriminatory statutes. There wasn't, affirmative action the way that we understand it today, at that time. So these are horses that were running in the same direction. Whether you embrace
Mhm.
the anti-classification view or you embrace the anti-subordination view, you're going to get rid of a law, like West Virginia that said that Black people couldn't serve on juries.
And so I want to try to break down a little bit for our listeners some of the concepts that you've gone through, so that we can make sure that they understand clearly the difference between the way the 14th Amendment was interpreted in Brown and the way that, the Supreme Court is interpreting the 14th Amendment now, and especially you mentioned in the SFFA case. So one of the things that came out of the SFFA case was this concept that discrimination based upon race, no matter if it's making preferences for a student of color, or denying a white student the ability to be admitted into a university, all discrimination is bad. And so, can you talk to our listeners specifically about how do we get from Brown versus Board of Education to all discrimination is bad, and not thinking about like the historical context behind the 14th Amendment that you've outlined?
Yeah, so I think that the way we get at it is that for a very long period of time, really until affirmative action in its modern sense took off in the Bakke case in 1978, the Supreme Court did not have to disambiguate or distinguish between the anti-classification and the anti-subordination principle, because both of them ran in the same direction. So if I have a statute that says Black people can't serve on juries, or Black people can't get married to white people, then you're going to strike down the statute regardless of which theory you choose. Both the anti-classification principle and the anti-subordination principle are going to invalidate that statute. Where the two theories tack apart is where the classification is being used, but not to subordinate Black people or racial minorities generally, but instead is trying to remedy that past discrimination against them. So that comes about in affirmative action. So starting in 1978 with the Bakke case and the whole line of affirmative action cases that run from 1978 to 2023 in the SFFA case, the Supreme Court had to grapple with the issue of, if you are using a race-based classification to remedy past subordination against a racial group and continuing subordination against a racial group, then is that the same as Jim Crow? And the progressives on the court prevailed for 4 decades, saying, of course it's not the same. That is ridiculous, right? 4 decades might be too long, but, for that, span between 1978 and 2023. But Justice John Paul Stevens, I think, put it best when he said, there is no moral and legal equivalence between Jim Crow and affirmative action. To confuse the two and to say that they're the same is to conflate a no trespassing sign, that's Jim Crow, with a welcome mat, that's affirmative action. So simply because they both use race-based classifications, I think most Americans would say, if I ask them, is there a difference between Jim Crow on the one hand and affirmative action like what Harvard was practicing? Of course, all of us would say
Hmm.
there's at least a difference. And many of us would say, in fact, these two things are the complete opposites of each other because one tries to continue racial subordination, that's Jim Crow, and the other tries to undo it, that's racially conscious affirmative action. So one of the things that the 2023 SFFA court did was to go back over that jurisprudence and to find the moments where the court was a little bit, imprecise because it didn't need to be precise in articulating what the principle of equality require. So to give you an example, one of the great celebrated dissents from, Plessy versus Ferguson back in 1896, a case that established separate but equal as being constitutional and was ultimately overruled by Brown versus Board of Education, Justice Harlan says, our Constitution is colorblind, period. There is no caste here. Or I think it's, there is no caste here, period. Our Constitution is colorblind, period.
Uh-huh.
Think about those two statements. They're actually each representing a principle, right? There is no caste here is the anti-subordination principle. You're not allowed to subordinate and make a second class or caste of citizens out of a group of individuals. And then our Constitution is colorblind is the, more formal, colorblindness anti-classification principle. So there are moments when the court talked about this in a, I won't say sloppy, but an imprecise way because it didn't need to be precise because both principles would lead to the invalidation of subordinating legislation. But when you get to 2023, the court just goes back and cherry picks all of those mentions of our Constitution is colorblind or any rhetoric that sounds an anti-classification and leans into that. This is very peculiar from an originalist intentionalist perspective. Again, the conservatives on the court who are driving SFFA are all justices who say they believe in interpreting the Constitution according to its original meaning. As we've discussed, if you go back to the origins of the 14th Amendment, it is really clear that what the 14th Amendment was established to do was to secure, right, the equality of the recently manumitted slaves. And there's no better evidence of that, even though I said there was no affirmative action during that period as such, is that there was a quasi-affirmative action type ethos where Congress voted out requisitions to all Black schools during that period. So if Congress really felt like the 14th Amendment that it had just voted out was being violated by sending out, requisitions to all Black schools, which favored Black people over white people and was a form of affirmative action in order to remedy the centuries of harm that Black people had suffered, then clearly they would have stopped themselves from doing that, but they didn't. So they clearly viewed no inconsistency between affirmative action on the other hand, as practiced in 1868, and the 14th Amendment on the other. And that suggests that the people who style themselves as intentionalists, who nonetheless embrace this anti-classification understanding of the 14th Amendment, have some explaining to do.
And so when you talk about all of this historical context, today history is contested or it's being contested. How would you talk to in your class future lawyers about what strategies can they use when we have Brown versus Board of Education that what you're saying is the assumptions of Reconstruction and the 14th Amendment were a given, but now we have the Supreme Court cherry picking from different cases from Brown to present day. How should a lawyer go about, arguing these cases before the Supreme Court? How do we make sure that we honor Brown versus Board of Education as this, canonical case that we learn in law school?
I think it's really important to do two things. First, I think it's really important to stand up for every single fact-based claim, that is being contested. So I think oftentimes it just feels like there's such a torrent of misinformation and disinformation that, we should just let some things go and sort of pick our battles. And I actually have a view that picking your battles is really important. But once you've picked it, fight every corner. So I don't actually debate, misinformation on a vast array of things. But because, civil rights is one of my passions, if you say anything that I think is wrong, I'm generally a pretty easygoing, friendly guy. But I will actually, as gently as possible, stick to my guns and say, where are you getting that information? And really stick up for and fight, right, for the truth, right, and the facts, that the history books, tell us, actually occurred.
I think that's really, really important as a former law professor and for our listening audiences to understand and learn the historical context that you've been giving us and become an expert in it. And each time your expertise is invoked, then, stand firmly in what you know is true about the 14th Amendment and Brown. I think that is like an excellent point for our listeners to, walk away with. And I wanted to highlight that.
I couldn't agree with you more, and thanks for the kind of amplification. And just as fuel to that fire, I think the second point is that lawyers are not going to be able to do this on their own, on our own. And so I think we need to think about this. Let's make sure that history gets told right accurately as being a broad-based project of education that extends far, far beyond the legal profession. So, public school teachers who are teaching, elementary school, right, are probably going to be just as much of a driving force on this as anyone, right? Making sure that history gets taught. I think opponents of civil rights understand this and trying to shut down factual discussions of history because of the emotional reactions that they might engender in the students who are learning about, their own perhaps families or demographic groups, participation in certain forms of oppression. I really bristle whenever anyone says, oh, this is so un-American to feel ashamed of your country. I actually think that reckoning with, the more negative, right, and horrifying aspects of our past is part of what makes me proud about my country. And I evidence that pride when I'm willing to face even the darkest, hardest parts of my country. In the same way that if you really love somebody, like you're willing to face with them, right, all of the things that they struggle with, all the darkness that is within them. So I actually don't think that my patriotism, for anyone's patriotism, is called into question by this looking at hard truths about our own nation's dark history. I think it's actually a symptom of our patriotism that we love the country. We're patriotic enough to be able to look it squarely in the eye and say, my commitment to you and this project of nation building is not contingent on my pretending that these negative things don't exist. Like, we have to face them. So I would say both of those things, and then together, both legal, education and lawyers sticking up for the truth, and fighting their corner and not giving up an inch, right, on these factual claims about, history. And then the other is a much more broad-based, understanding of education. And it's really that collectively means that the kind of shameless kind of cherry picking of history becomes that much harder, because if you have an educated citizenry, if you have an educated electorate, then they're simply not going to accept, a court, whether it's the Supreme Court or any other court, or, a politician who says this is how it happened, where we can actually say, no, that is false, right? And just being able to say that is not true in this, era where we all feel like, as Daniel Patrick Moynihan once said, it's no longer that, you have a right to your opinion, but not to your own facts. Like, it seems like everyone today seems like they're entitled to their own facts. And I think we really need to set our face against that, which is to say, I'm happy to debate, I'm happy to explore. I'm always happy to read more. It's what I do for a living. But at a certain point, like, we cannot be debating, right, whether or not things that actually historically happened, whether they happened or not, right? So something as basic as, did the 14th Amendment embrace an anti-subordination view of equality is something that is just beyond peradventure. It's beyond debate, right? Just based on the historical record. And we should be able to stand up and say that.
And I really love these last comments because they are right on target with what Brown stands for, which is, equalizing access to education, and a quality education where people are, become critical thinkers and they learn our history. So those points are just right on target. I know we could spend so much time talking with you and learning from you. I'm going to just wrap it up with two more questions for you. So, what part of the Brown versus Board of Education opinion keeps you inspired today?
Yeah, so I have to say, that I've spent my whole life working specifically in LGBT rights. And I will say that one of the things that has been most um, inspiring for me about civil rights generally is that I'm completely unable to be a cynic about the American project and the project of civil rights because of the changes that I've seen in my own lifetime. And this is going to seem very parochial, but it is almost uncanny for me as somebody who was born the year of Stonewall in 1969 to think about the life I thought I was going to be able to live when I came out in my early 20s, vis-a-vis the life that I've been able to live. And that all has to do with civil rights. So if I think about, what I imagined when I came out in my 20s, I thought, oh my goodness, like I'm not going to be able to have a successful professional life. And more deeply, I worried because this is a more important thing to me. I'm not going to be able to have a personal life. I'm not going to be able to marry. I'm not going to be able to have children. And that was the hardest thing about coming out for me. And the change that I've seen in the decades that I've been on the planet has been nothing short of staggering. So I co-wrote the human rights brief for the Lawrence versus Texas opinion case in 2003, and that abolished the criminalization of sodomy in the United States and essentially legalized same-sex sexual conduct. When I wanted to marry, Connecticut allowed me to marry my husband. It was not recognized federally, right, in 2009, but it was recognized by the state. And then in 2015, Obergefell versus Hodges made it the law of the land. So it's really the grace of, as Pete Buttigieg says, one justice on the Supreme Court that made all the difference, right? And
Hmm.
how my marriage was recognized in this country. When my husband and I, as I mentioned earlier, decided to start a family, surrogacy laws had changed enough in the United States that we were able to have our two children and to welcome them into the world. And so it's led me to just be completely incapable, despite all the challenges that we see today, of remaining anything but, incredibly hopeful about the American project because I see what civil rights can do. So guess what all of those opinions, have in common? The Lawrence case, the, Obergefell case, the, surrogacy cases, they all occur under the overhang of Brown versus Board of Education. Because when people think about, what are we struggling for here? What is the equality principle at stake here? The most easy referent against the touchstone against which all of this is measured is this similar to Brown? Is this similar to the ringing, clarion call for justice and equality that was issued in Brown? So I see Brown everywhere I look, even though I work, arguably like in a parallel field of thinking about LGBT civil rights rather than about racial civil rights. But I see Brown's hand in everything that I do.
That leads us to our last question, which is in celebration of the 70th anniversary of Brown, LDF has come up with the phrase, "We are all Brown." So, what does "We are all Brown" mean to you?
Yeah, I love the slogan because I was um, reflecting on this as well. So, in some ways, the universality of Brown, I think, is such a critical point because I think we often think about it as, oh, like we let, you know, Black and brown, individuals, come into schools because otherwise their hearts and minds would have been ruined in a way that it would be impossible to remedy. And, that's actually language from Brown itself, as you know, but your listeners, may not. But when you think about it, right, like, the justices clearly meant it's only racial minorities who are hurt by segregation, but white people are hurt by segregation too, right? Because you think like if you grow up in a system that teaches you that you are superior to others simply by dint of your race, that is corrosive to the spirit as well. And so I think if you ask the justices in a moment of enlightenment on the Brown court, whether or not they felt like white children were also hurt by segregation, I think that they would also say yes, maybe in a different way, certainly in a less severe way, but they were hurt as well. And of course, all the justices grew up in that system. So they're the product of those forms of education, and their own hearts and minds were at risk of being ruined as well. So, this is not colorblindness. Like, I want to explicitly say, like, I still, believe both as a matter of law and as a matter of practice in the anti-subordination view. But understanding how subordinating practices hurt everybody is, to me, the message of we are all brown. That if we can actually have a more inclusive society, even the people who benefited from those old systems of subordination, right, are also going to be enriched and sort of lifted up and elevated because we live in a more egalitarian world. Do we really feel like, oh, we want to preserve the system because this system unjustly benefited me? I think we all know, right, that diminishes all of us, right? And so a principle of equality often feels like we're leveling and we're taking away privileges from people who once had them. But if you think about how those privileges are based in a deep, deep sense of injustice, I don't want people to think I'm just giving up privilege. I want them to think I'm giving up this injustice in myself and society. And it's in that sense that I really love the slogan, "We are all brown."
Thank you for that. I really, really love the way that you contextualize your life as you envisioned it at 20 and where you are now, because I think that, the day-to-day work of doing civil rights work, you're in the moment. And I think reframing from the perspective of what I thought my life could be and what it is now is very inspiring principle for our listeners to kind of take away from this, especially in this moment. So thank you so much for your time. This was just like invaluable information.
Oh, it's a joy to be with you, Karla. Thank you so much for having me.